In every larger conflict, hundreds or thousands of human rights violations are committed. But not every violation will be investigated and prosecuted as a crime. The mandate of international criminal courts and tribunals is typically tied to international crimes. But what is an international crime? Welcome to video 2. There are different theories to explain what international crimes are. A common perception is that international crimes are crimes that are so serious that they affect the international community as a whole. Or in other words, they injure something fundamental to being human in a way that domestic legal systems fail to address. But this conception is slightly misleading. Certain international offenses, like rape, murder or torture, are also criminalized under domestic law. Some domestic crimes may be just as heinous or grave as international crimes. Typically, two theories are used to explain what an international crime is. According to one theory, the definition of an international crime is tied to the nature of the offense. The theory draws on the Latin concept of malum in se, which means wrong or evil in itself. A crime is considered inherently wrong because of its evil nature, independent of regulations governing the conduct. This definition captures a wide range of crimes. A classical example is piracy, which is the first international crime. Pirates on the high seas were called enemies of humankind. Any state could prosecute them regardless of nationality or the place of commission of the crime. The weakness of this theory is that it remains blurry. Many acts shock the conscience of humankind. The theory does not tell us who determines what an international crime is. The second theory, malum prohibitum, which means prohibited evil, relies more directly on regulation, in particular the level of prohibition. According to this view, an international crime is an act that is directly criminalized by international law. A typical example is a violation of a criminal norm that is contained in an international treaty or international customary law. Classical early examples are the United Nations Convention on the Prevention and Punishment of the Crime of Genocide or the so-called grave breaches of the 4 Geneva Conventions. It is also increasingly accepted that crimes included in the jurisdiction of the International Criminal Court are international crimes. In my view, both theories are required to understand international criminal law. Some crimes are international crimes without being enshrined in an international treaty. For example, the crime of aggression or crimes against humanity were considered as international crimes long before the ICC statute came into force. At the same time, the evil nature of the act is not always the decisive criterion. In many cases, the prosecution as international crime is driven by additional considerations, such as the lack of capacity or the failure of states to act. The most convincing approach is to regard an international crime as a crime defined by international law. International crimes share some resemblances with domestic offenses. They typically include two classical elements known from domestic law. First, the material element called actus reus. It includes the objective elements relating to the crime. They are the illegal conduct of the perpetrator, the consequences of the act, causation between the act and the consequence, and in some cases, specific circumstances related to the subject or the object of the crime, such as the minimum age of victims. The second element is a mental element. It is called mens rea. It describes the culpable frame of mind of the perpetrator. The individual requirements depend on the crime and degree of responsibility. They include cognitive elements such as knowledge, volitional elements such as intent, and certain forms of awareness of risk or negligence. What makes international crimes different from ordinary domestic crimes is the context in which they occur. It is factors such as the existence of an armed conflict or the systematicity or scale of violations that mark the difference to ordinary offenses. Qualifying conduct as an international crime as opposed to an ordinary crime has an effect on enforcement. It enlarges the scope of accountability for perpetrators. The most immediate consequence is that qualification of a crime under international law allows investigation and prosecution irrespective of whether the conduct is criminalized domestically. A classical example is the prosecution of Nazi discrimination under the Holocaust that was authorized under the legal order of the Third Reich. But the qualification has other important consequences as well. The nature of the offense may enable states to try perpetrators in the absence of any link between the accused and the state exercising jurisdiction. This is called the doctrine of universal jurisdiction. Second, the label as an international crime may prevent the invocation of immunities. A famous example is the case of former Chilean dictator Augusto Pinochet. In this case, the House of Lords held that Pinochet could not invoke immunity before British courts because torture does not form part of official functions. The International Court of Justice also specified in the famous arrest warrant case, Congo versus Belgium, that immunity does not prevent investigation or prosecution before an international criminal court and tribunal. Third, the international character of the crime may render certain statutes of limitations inapplicable. This makes broader prosecution of crimes committed in the past possible. The jurisdiction of international criminal courts and tribunals is mainly centered on three categories of crimes: genocide, crimes against humanity, and war crimes. They are called the core crimes and are typically committed as part of mass atrocities. We will study these crimes in the next videos, starting with genocide. We're looking forward to seeing you there.